Okay, gentlemen, I believe we're ready. You may call the next case, please, Miss Ashley.
Dominion Real Estate, LLC versus the Wise Group, Inc. et al.
And you're in a different position now.
I moved across the room, Your Honor. Good morning, Your Honors. Nicholas Bolster here for the defendants in this case, the Wise Group, Inc., the Lux Development Group, LLC, and Alan R. Wise. I know the court probably hears this a lot and might hear it every time somebody stands up at this podium, but we have an important issue for the court to address today. I speak
rebuttal time?
Oh, excuse me. 3 minutes for rebuttal, please.
How many?
3 minutes for rebuttal,
Three?
please.
Okay, you may proceed.
But today, in contrast to what we just heard, it's a much more straightforward issue. The remaining issue on this appeal is whether Dominion's second appeal was frivolous. And I'm sure the court's familiar with Section 27-1-122 and the standard applicable to it. Of course, familiar with Whalum and Marshall, Young v. Barrow. An award pursuant to that section is discretionary, and it's only awarded when this court determines in its discretion that an appeal lacked merit and stood no chance of success. What we respectfully argue to the court today is that Dominion's second appeal was frivolous, but first I want to address exactly how we got there, because that will feed into why it was frivolous. So the court just heard the case about the fraudulent transfer. That included Dominion Real Estate. Dominion Real Estate got out on summary judgment, and then Dominion turned around and sued us for malicious prosecution. We moved to dismiss those claims. Judge Kelvin Jones, then with the Eighth Circuit, granted our motion, and then we brought up the issue of getting attorney's fees with Judge Jones. He did not award anything. We had kind of a strange situation come up where we moved to get an award of attorney's fees to comply with a state of hair, which is a Supreme Court decision more or less saying that to deal with this finality loop problem that we get with Section 2012-119C3, that you should go ahead and request your attorney's fees so that the court can stay the award, stay the calculation of the award and the actual award until after all the appeals have been exhausted. So we just wanted Judge Jones to say, yes, you get your attorney's fees, we'll deal with that later after the appeal. We had kind of a snafu about hearing dates, and so we ended up at an emergency hearing before Judge Jones where he more or less didn't do anything. He didn't rule on our motion, he didn't deny the motion, it just kind of sat there. And so after that, Dominion filed this notice of appeal. The circuit court clerk starts preparing the record and then reaches out to the appellate court clerk and says, well, hang on, we got some issues that are still pending in the trial court. What are we supposed to do about this? We looked into the record and we tried to figure out exactly what the circuit clerk was talking about, and our only guess is that it was our still pending application for attorney's fees because it had never been addressed. And so we don't know what the appellate court clerk told the circuit court clerk. I imagine they might have said that based on Court of Appeals precedent, that doesn't inhibit finality, that doesn't inhibit taking an appeal of that issue. But whatever happened, the circuit court clerk sent over the appellate record, and then the appellate clerk filed it. The clerk filed it on September the 7th, 2022, so per Rule 29A, Dominion's brief was due on or about on October 27, 2022. Dominion did not file the brief, so on October the 31st, 2022, the appellate court clerk entered an administrative order noting that their brief was overdue and telling them to file it within 10 days. Dominion did not file its brief or did not respond or ask for an extension or anything, and so this court dismissed the appeal. That was appeal number 805 on November 22nd, 2022. So then we're back in the trial court. The appeal has been dismissed, so we move for our attorney's fees. In response to that motion, we never really got a response from Dominion. Dominion at first filed a response, but that response only said that the hearing date's not going to work for me, let's move it. So we moved the hearing date. Dominion had a new response date. They just filed a placeholder document saying, here's a response, but we are going to amend it tomorrow. And then Dominion never filed anything. So we had our hearing with the court. We had that hearing on January the 13th. We put on evidence that we had incurred $19,807.50 in attorney's fees. The court granted us the attorney's fees, reduced that amount to $10,000 in keeping with the statute. Then 3 days after that hearing, after the court has orally granted our motion, Dominion files a supplemental response. And that supplemental response is where we begin seeing these issues first brought up about whether Judge Jones actually denied the application for attorney's fees or whether the basis for the dismissal and whether that affected our ability to recover attorney's fees. And I stress that this was a supplemental response because it presented those issues to the trial court in a way the trial court couldn't really do anything with them. And Dominion could have filed a Rule 5402 motion, a Rule 5904 motion, a Rule 60 motion, something that would actually put the court in a position to do something. You're not supposed to use those motions to bring up new issues anyway, but just filing the supplemental response to a motion the court had already granted orally, it didn't leave the trial court with many options about what to do with that. And so that leads us, so the trial court granted our attorney's fees. That led to this appeal. That's Dominion appealing the award of attorney's fees, and Dominion puts up 5 issues for this court to, or put up 5 issues for this court to address. The first was the court's May 17, 2022 order a final order? Second, did the dismissal under Tennessee Code annotated section 24.2-105 preclude an award under section 2012-119C? Did the court err in awarding attorney's fees prior to the exhausting of an appeal pursuant to Tennessee Code annotated section 2012-119C3? Number 4, did the court err in awarding attorney's fees without conducting a hearing? Number 5, if applicable, did the court err in dismissing appellant's complaint under Rule 12.026? Now, of course, Dominion has dismissed its appeal, and so all we're left with is our claim that this is frivolous, but I'm going to walk through these issues and explain to the court why they were waived or why they stood no chance of success. So the first is the court's May 17, 2022 order. That was the order granting, through which Judge Calvin Jones granted our motion to dismiss. Again, that's a position that we never saw argued before the trial court in any meaningful way until we get that supplemental response. So in our view, it's been waived. But even looking at the claim, the trial court's order didn't mention the issue of attorney's fees. We requested an award. We requested the award. We filed 2 motions and 2 memoranda and then 2 replies. We requested in each and every one of those documents to make sure that we preserve the claim on appeal. And that's really all we had to do. In our briefing, we point the court to Donovan v. Hastings and Irvin v. Greenwise Homes LLC, just to clarify that if you want attorney's fees for having a claim dismissed pursuant to section 2012-119C, you need to make that claim, that request, in your briefing on it. Because we also have the court's recent decision, Pagliaro v. Moses, from which we find out that you can't wait until after the appeal to request those fees for the first time. The request has to be made before the appeal. And so what we were, again, trying to do was just make sure we were making that claim before the appeal, make sure our request for attorney's fees was preserved. So again, even if Dominion had not waived this issue, it runs squarely against very clear authority from this court on what you have to do to preserve your claim for attorney's fees. Next up, we have this issue that the trial court dismissed the Dominion's complaint on independent alternative grounds. We had 2 bases in there to dismiss the complaint, the malicious prosecution complaint. The first was that for failure to state a claim. The second was an issue with service of process. Dominion had Mr. Wise, both in his personal capacity and as the representative of these other entities, served as he was sitting at the counsel table for the trial of the case the court just heard this morning. So we argued that was defective and was not proper service. Judge Jones granted the motion to dismiss on both issues, and that's not abnormal. That's something we've seen before. We've seen that in, I think we cited 4 different cases in our briefing that deal with that. So again, this issue is not brought up in a timely and effective way. It's not presented to the trial court for the trial court's consideration, and even looking at it, it doesn't go anywhere.
Is there any reason why in your motion to dismiss you didn't cite 12.026? In his order, he says you only cited 2 and 5. I know ultimately he dismissed it because of the statute of limitations, and that would be failure to state a claim.
Are you referring to Judge Calvin Jones' order?
Yeah. If you look at the first page of his order, he said you moved to dismiss pursuant to Tennessee Rule of Civil Procedure 12.022 and 12.025, but no mention of 6.
I had not
Okay.
recognized that, Your Honor.
Okay.
I can't explain why that would be there.
I don't guess it matters in that ultimately he granted it for failure to state a claim upon which relief to be granted. And that would get you into 06, okay.
But I can only explain that as a typo because it should have been 12.05 and 12.06, because 12.05 is insufficiency of service of process, 12.06 is failure to state a claim. I can't explain that, Your Honor. I apologize. Next issue is issue number 3. Did the court err in awarding attorney's fees prior to the exhausting of an appeal pursuant to Tennessee Code annotated section 2012-119C3? As it's expressed, that issue is not waived, but it's based on a fact that never actually happened. What Dominion is arguing there, that rather than dismissing its claim, this court remanded the case to the trial court to deal with these still pending issues. And that's just something that didn't happen. We can look at the court's orders. We can look at the administrative order and the court's order dismissing the appeal. There was no remand. The case was dismissed because Dominion didn't file the brief, and so that ends that issue, and I don't see a way of disputing that anymore. The next issue is, did the court err in awarding attorney's fees without conducting a hearing? That's kind of an interesting proposition because Judge Ingram did hold a hearing. It was January 13, 2023. So that issue doesn't really go anywhere. But what Dominion argues in its brief is that there are other defects with Chancellor Ingram's order. We addressed all those in our briefing, but the real problem there is that those specific problems were not identified as an issue in Dominion's statement of the issues, and so we know pursuant to Rule 27A4, those issues get waived. The next issue that Dominion brings up is, if applicable, did the court err in dismissing appellant's complaint under Rule 12.026? And that, of course, is the first order that from Judge Calvin Jones dismissing the complaint. We already had that appeal. The appeal was dismissed, so we point out in our briefing that's law of the case now. We can't go back and relitigate that. And so in the final analysis, we pointed to, in our briefing, various cases where the courts have looked at issues that arose in this case and decided that the appeal was frivolous and decided to award discretionary, and the discretion decided to award fees. So that we cite to 21st Mortgage Corporation, that's where a party failed to comply with Rule 27A. LaBelle, which is where the appeal had no prospect of success because the issues had been waived. We saw here that was 3 of the 5 issues. Young, where a party files an appeal for the purpose of relitigating claims. That's what we saw with that final issue. And then in re conservatorship, where a party challenged an order on multiple grounds but doesn't argue about one of the other grounds. And then finally, Stooksbury versus Varney. It's where a party files or a party relies on a construal of facts and the law that does not align with reality. And that's what we see happening with this issue of, well, the Court of Appeals remanded the decisions. No, well, the court didn't remand it. The court dismissed the claim. And so I've read over Dominion's reply brief in this case, and I have not picked up on any response to our waiver points. I think what Dominion has been doing so far is just relitigating that first case, relitigating this case, and more or less saying we're the bad guys and we're being mean. They bring up this issue of, I see my time's running out, I finished that comment very briefly. This issue of Dominion Real Estate being administratively dissolved. Again, we don't think those issues goes anywhere. And so that's our position on appeal here today.
Thank you.
Thank you.
Good morning, Your Honor. It's Jim Roberts on behalf of Dominion Real Estate. As they say, the past is prologue, and I think it's sort of maybe coincidental, maybe not, that the prior argument was a case that my client was a part of. The Allen Wise versus Dwight Holland case, we were named in that case. In fact, everyone who possibly knew Dwight Holland was named in that case because it was nothing more than a personal vendetta by Allen Wise and his entities against everyone remotely associated with Dwight Holland. My client, Dominion, got caught up in that. It took months, but we finally were able to escape that case on a summary judgment. It was turned into a Rule 5402 order with Chancellor Lyle. And of course, the Wise and Lux appealed that, and this court affirmed that dismissal back in March of last year, which I certainly appreciate. My client purchased a piece of real estate, paid $350,000 for it, and got caught up in a fraudulent transfer action over a $35,000 debt by someone who wasn't even in the chain of title. And we finally were able to get out, really not because of my brilliance, but because the offending party, or the plaintiffs in the underlying case, couldn't even establish the value of the property, which they were accusing my client of paying $350,000 for in a fraudulent transfer to cheat them out of $35,000 debt. Now, that's not what we're here for today, but it is sort of the past is prologue issue. My client, Dominion, has suffered the consequences they wanted. They set out to destroy my client and everyone associated with Dwight Holland, and they drove my client into the ground, and they were administratively dissolved last fall, and they're never going to cease to be again. I don't even know if they're a proper party before this court. I certainly think this issue is now moot. They're gone. There's no relief that can be given to anybody. And because of that, I filed a notice of dismissal of the appeal because I thought that was the appropriate thing to do. And I guess I expected it to go away because they won. They got what they wanted. They didn't get any money out of my client. They tried to, but we got away from them, and we filed a notice of dismissal to get away. Not surprisingly, the appellees in this case jumped up and said, wait a minute, we raised an issue. It's a frivolous appeal. And so we have to brief that, and we have to be here today out of a personal vendetta against my client. And that's okay. Sometimes the law is that way. But that's why we're here. I'm going to focus on one thing if I can. And one of the issues here was after this case went back to the trial court in January of 2023, they filed a motion for attorney's fees. And I don't want to get into the whole arguments that my brief sets that out. But part of that is we were objected to that motion for attorney's fees because they were requesting almost $20,000 for what were really skeletal motions to dismiss. And we had a problem with that, two problems. One is that the case was dismissed for lack of service process. Wasn't dismissed under Rule 12.026. It wasn't a failure to state a claim. It was a service of process failure. And whether that was right or not, I originally was going to take up, I don't care anymore. But that's why it was dismissed. And the statute that awards or allows awarding of attorney's fees requires that it be a 12.026 dismissal, and it just simply was not that. And we would say that renders the issue moot. But also the fact that there's no relief that this court can really give these folks because my entity no longer exists. I keep thinking they won. But when we were back in court in January of 23, they filed, again, their motion for attorney's fees. And I asked for something pretty simple. On behalf of Dominion, I said, prove to me they earn these fees. Show me they're reasonable. Show me the lodestone factors that tell me that this is a reasonable amount of money because the attorney fees application included a lot of things that weren't proper. Well, we never got that hearing. We never got anything. We just got a rubber stamping of an award of attorney's fees. And I would submit the appeal of that issue, forget all the other stuff for the moment, but just the mere appeal of that issue, whether those attorney's fees were properly granted, is a viable part of this case and a reasonable basis to appeal, that this appeal was not frivolous. Now, whether we'd prevail or not, of course, that's always another issue, but it certainly wasn't frivolous. When I did the research on this, I looked at it. This court has ruled this, as we have observed on several occasions, that our standard is is altered somewhat in the absence of a finding of reasonableness and of the awarded fees and a discussion of the applicable factors in determining such reasonableness. And if you go back to that January 23 order, there's none of that. And so it's really not under abuse of discretion standard. It says this is from the Southwind residential property case cited in my brief. When the trial court has exercised its discretion in light of the appropriate factors and found the fee to be reasonable, we simply review for abuse of discretion. Where, however, there is no finding that the fee is reasonable and no way to ascertain whether the court made the award in light of the appropriate factors, there's no way for us to accord the normal deference to the trial court. And that is a large part of our appeal, was the idea that the trial court did not give this court, or us, the appropriate information to make a decision. And if that could have been the only issue we appealed, and Your Honor, I would submit that that issue alone keeps this case from being frivolous. Whether Mr. Wilson was correct about anything else, I don't even care. But the mere fact that we raised that issue keeps this appeal from being frivolous. There was no discussion of warranty. This was just a rubber stamping. We specifically requested there be a hearing. We specifically requested there be some sort of determination of how they spent $20,000 and why we should have to pay for process fees and all this stuff that were outside that statute. But we never got any of that. That's how justice is sometimes. But that would have been a part and parcel. Now, to go back to the rest of the case, whether it was dismissed properly, I do believe that the underlying facts show that this case was dismissed because of service of process. And I believe the trial court got it wrong, that the statute related to not being able to serve people applies only to witnesses, not parties. But I don't even want to argue that. I don't even care about that anymore. It was a valid basis to appeal. And the law is pretty clear about witnesses being protected when they're served out of their counties, but it is not as clear or clear at all as to whether parties can be served under these circumstances. submit that that is not a frivolous basis. I don't want to go through all the brief, but just the idea that somehow we can't get away from these people. And maybe we should have stayed away, I guess, and this is what I argued to Chancellor Lyle in the underlying case. I said, just get my people out of this crazy lawsuit. And here we are, 2024, and they're still fighting over it. Dwight Holland and they're still going at each other because they have unlimited money to spend on a $35,000 debt that was paid in September of 2019. Paid in full. 2009, and they're still fighting over it. Why? Because they have a lot of money and they have aggressive lawyers, good lawyers. But that's what's wrong with this case. That's what's wrong with the judicial system sometimes. And I know we can't fix that. But in this case,
Now,
Dominion had a right to appeal that award, and I think it's appropriate, whether they win or not. Yes, sir.
but your client filed a malicious prosecution case, right?
I'm sorry, did I?
Your client filed the malicious prosecution case.
Yes, we did. We felt that they had been drugged through the mud on this, and we relied, Your Honor, on the Moffitt case, which I cite in the brief. I'm going to flip to it real quick here, which talks about when the commencement day arises for filing a malicious prosecution case. And we'll concede, Your Honor, there are multiple dates. There are many dates in a case where a malicious prosecution case could be filed. And we believe, I assert, that until this court rendered a final order, which it did not do until March of 23, that our statute of limitations wouldn't even begin to run. And that is part of our appellate brief, is that we filed it when we filed it because we knew that Mr. Alan Wise, who we believed was out of the country, was going to be in the country. I think that's in there. But we did that because he was going to be in the country. But my position would be is that we could have waited until March of this year because of this court's ruling in March of last year to file the case. If anything, we filed too early, not too late. Now, that was one of the issues that we were raising in our appellate brief, on appeal, and I still strongly believe that. And I believe that the court that when you look at malicious prosecution actions, that reliance upon that Moffitt case was reasonable. And that was admittedly a criminal case, but the courts were very clear that until there was a final order, and after appellate review, the statute wouldn't even begin to run. We filed before that date. And so I think we absolutely were appropriate in that. Again, unfortunately, those claims are now moot because Dominion Real Estate doesn't exist anymore. And it's never going to exist again. But I do believe, Your Honor, that we were absolutely right in doing that we could have followed up until, well, I guess we still within the 1 year, actually. It was not until 4 days from now, that we would have had proper authority to file in that period on the statute of limitations. This court might have ruled against us, I'll grant you that. But that doesn't make our appeal frivolous. And I guess that's what I tried to address in my pleading in January, addressing the only issue here, which is all of our theories had merit. Maybe they wouldn't win. They all were done in good faith. They all were done to try to right what's just clearly a wrong. And if only one of them, and I think all of them had merit, but at least if we just focus on the awarding of attorney's fees without any consideration of the RPC Rule 1.5, with any consideration of any of the lodestone factors traditionally discussed by the court, without any sort of discussion whatsoever, that seemed to be a reasonable thing to ask this court to address. How they ran up $20-something thousand in a 6-week period, I don't know, but it seemed like a reasonable inquiry the court should have made, and it failed to do so. I would have hoped that this court, at least, I'm speaking of that in issue specifically, would have remanded on that basis to the trial court to say, where did you get this decision? How do you decide? Why did you include all these things that were unrelated to the motion to dismiss? Why did you include all these things? That there would be some sort of reasonable, and that's what this court expects. Every case I've ever read on it talks about expecting the trial court to lay out the factors so that you can do a proper review. I submit you.
How do we get there if, as in this case, your client dismisses their appeal?
I'm sorry, I just.
We are not forgetting, are we, that Dominion dismissed its appeal in regard to the attorney fee award?
Well, because I wasn't certain what to do, when I got notice of the administrative dissolution, I went to my client and said, what is your intention? And I said, he's just going to let it go. It's too much of a magnet of the vendetta based on the underlying case. And I said, that's pretty smart. They have no money. They have no assets. They've been notified under the Tennessee statute, I'm sorry, I don't have it in front of me, where you notify creditors that you're going into dissolution. That's been done with the Secretary of State's office. I think they would have had a good argument, Your Honor, and I think it would have been a prevailing argument. But in that they don't exist anymore, I guess I sort of expected this court to just enter a order saying the issue is moot, and I did not want to show up because of the orders this court had entered. I don't know what relief this court can give the appellees in this case against a defunct entity. But it doesn't surprise me that they would want to keep fighting, and I'm sure they'll go to the Supreme. I'm surprised they didn't go to the Supreme Court back in March of last year. I don't know what else to say, Your Honor. I think my clients were right. I think they did what was appropriate. I think the decision to give up was appropriate. We gave up. We tried to get away from these people, just like we tried to get away on motion for summary judgment in the underlying case, and they took us to the Court of Appeals. And we had to stay in the case another 3 years. They made a decision they wanted to get away. And I would submit, Your Honor, that I've laid it out in the brief, but everything we did was reasonable. Everything we did was to try to right what we thought was a wrong. That is not frivolousness, as this court has defined it in the past. It's not completely devoid of merit. It's not something that was done spitefully or inappropriately or with bad intent. They believe they had an underlying case. They also wanted to get away. That's pretty much all I have to say. Thank you, sir.
Thank you.
Let's do additional questions.
Your Honor, Nicholas Bolster here again. I will address just briefly why we actually joined Dominion Real Estate LLC to that initial case. That was because Dominion LLC was the last title holder of the piece of property that had been transferred down, so we named them as a transferee. We weren't targeting everybody, but this wasn't a crazy vendetta. We were just naming all of the relevant parties. Judge Armstrong, I appreciate your question because from the get-go, I've heard Dominion talk about how they really just wanted to get away from us. They didn't want anything to do with us. They wanted to get out, get away, and say goodbye. And that's perfectly fine. They had done that when they prevailed on summary judgment and succeeded on the appeals. But then they turned right around and sued us again for malicious prosecution. So here we are arguing about this issue here today. Mr. Roberts has thrown a whole lot of issues at the court, and it's kind of hard to figure out what's important and what is not. A lot of those issues that Mr. Roberts brought up dealt with the dismissal of the case. And that now is done because we had that appeal. Dominion didn't file a brief. It's granted. It's law of the case. We can't go back there and deal with it. All we have before the court right now, or what we had before the court, was just the issues Dominion raised in his brief related to the award from Chancellor Judge Ingram. Again, I heard this issue about whether Judge Ingram complied with the Supreme Court rule. As I mentioned moments ago, the problem is that the issue that is nested under is that did Judge Ingram hold a hearing? And it's just a matter of fact, Judge Ingram held a hearing. It was January the 13th of 2023. We argued about all of this. It was there on the record. It came up on appeal, and then Dominion dismissed the appeal, and so we have all of our arguments in the briefing before that, and that's where it stays. But of course, our position is that issue was not properly raised. It wasn't properly presented to the court, and so it's waived anyway. I will spend just a little more time talking about this issue of mootness because I know the court still has a pending motion for it too. Just because Dominion Real Estate has been administratively dissolved does not mean it's gone. As the court is, I'm sure, familiar with, even after an LLC has been dissolved, actually and effectively dissolved, the members of that LLC can sue and be sued in the name of that LLC for claims emerging from when that LLC was still active. So the idea that Dominion Real Estate has just been administratively dissolved doesn't really affect anything that's going on in this case right now. It doesn't moot the case. And we still have this, our pending issue about whether this appeal was frivolous. So respectfully, just because Dominion Real Estate has been administratively dissolved doesn't change anything. And that's considering if the court is going to take notice of that, because that, of course, is something that happened after all the events occurring in the underlying case. So for all those reasons, we disagree. We think Dominion has waived most of its issues. If it didn't waive the issues, they were based on this idea that It's an initial brief, or the initial appeal was remanded. None of that happened, so all those issues were waived or they have no factual support, and that's why we've brought the issue today to the court of whether that appeal is frivolous.
Do we have a transcript of that January 13 hearing before Judge Ingram?
There is no transcript, Your
That's
Honor.
not in the record. Okay, all right.
Thank you.
Thank you, gentlemen. Appreciate your argument, appreciate your briefing. We will take the matter under advisement and attempt to render an opinion at the earliest possible time. You may be excused.